Hey everybody, welcome to Thursday night. It's John Skiba here from the Consumer Warrior YouTube channel, and each and every week on Thursday night we meet here on YouTube and on Facebook to discuss different topics related to dealing with debt collection lawsuits, dealing with bankruptcy, all those kind of things. For those of you here for the first time, I am a bankruptcy attorney in the state of Arizona. I also do a lot of work defending against junk debt buyers like Portfolio Recovery Associates, Midland Funding, all those kind of people. So we deal with those. We talk about it. As I always say, I can't give out legal advice, and you shouldn't construe any of this as legal advice. I'm licensed in the state of Arizona and nowhere else. So I don't know the rules. I don't know the laws in other states. And you really should contact an attorney in that particular state if you have specific legal questions. So the way we do it is if you have a question, go ahead there in the comments section or actually it's the chat section on YouTube. Go ahead and put the question in. I'll put it up on the screen and we'll discuss it. We have a lot of people who support the channel. Dave Lamb, I appreciate it. Each and every week here supporting the YouTube channel. I sincerely appreciate that. And then we have an ALP with another contribution here. I appreciate all that. And then we got Darlene. Hey, Darlene, it's good to see you tonight. So, as I tend to do, I like to go through and find questions that are listed on the channel and post some of those because I think I try to find ones that have some common applicability with it. A big topic that I have done before is on private arbitration and dealing with debt collection lawsuits by forcing them into private arbitration. This first question goes along those lines, and they say that they are trying to strike the arbitration in court. The original creditor is suing. They're claiming that since they filed a small claims case first, that the arbitration is not a factor now. So the backdrop to this is if you are sued by a debt collector, most debt collection lawsuits or credit card companies have what's called an arbitration clause in it. And what it says is either of you can opt out of the legal process and go through a private arbitrator who's kind of like a paid judge. Now, they don't want to do it because it's super expensive for them to do it. It's about sixes when it comes to you as the consumer is what it costs, but it costs them a lot more. And so this question was a good one in asking, well, what happens if you get into court in the arbitration and they're saying, no, the arbitration clause doesn't apply anymore. We're in court. Let's just stay here. Read that arbitration clause very carefully because the arbitration clause, I don't think I've ever seen one that doesn't say either of you can elect to force arbitration. So just because they elected to file the case in a court doesn't mean that you can't elect to take it out of court. And the court should adhere to that, particularly in an original creditor case like this. They should they should be provided. They should being held their feet to the fire on it, make them adhere to it because it's their contract, it's their agreement. They drafted it. They're bound by it. So. All right, let's see what Darlene had to say today. During a civil trial in Arizona, if the plaintiff's attorney motions to dismiss without prejudice, how can the defendant insist or demand that the lawsuit be dismissed with prejudice? That's a great question. So the whole distinction is if a lawsuit is dismissed with prejudice, it means that it can never be refiled. It's done. They can't litigate that particular case anymore. If it's dismissed without prejudice, it means that the court could dismiss it and they could turn around the very next day and refile it. So there's some flexibility there that you don't want, obviously. Now, if they are filing a motion to dismiss without prejudice, and particularly if it's not in response to something you said or you did or you filed with the court, that's when my spidey senses start tingling. There's something wrong with the case. They've got a problem with the documents and they want to try to regroup. And so I would file an objection to that and say that the only way we're going to dismiss is if it's with prejudice. And you can say, look at the hardship that this has caused me. They brought this lawsuit. You've had to file an answer. You had to pay filing fees. You had to do all these things. You may have had to hire an attorney. All of the stress and everything associated with it. If they want to sue, now's the time to do it. And it should be dismissed with prejudice. It's not to say that the judges are always going to agree with that, but it's definitely something that I would recommend. So, let's see what else we have here. We got Noob here. Noob Landers. How do I obtain the original agreement from the plaintiff? Do I ask for it in my answer or do I ask for it after I file the answer? I'm going to ask maybe a better question. Why do you want the original agreement? And here's why I asked that. I can tell you how to get it. But I can also say, why do you want it? And this kind of goes into the whole discovery thing that I often talk about when it comes to defending debt collection lawsuits. A lot of times the initial reaction is, you know what, these debt buyers don't have anything. I'm going to force them to get it. And my response to that is, the burden is on them. When they filed the lawsuit, the burden is on their shoulders to prove up their case. You don't have to disprove anything. And so if you force them to go get the original agreement, if it even exists, they're just going to use it against you. It's like asking someone to go get a baseball bat so they can pound you over the head with it. That's what they're going to do with it. So I guess that would be my first question is why do you even need it? And then, but if you do need it, the proper way to do it, it's usually not requested in the answer. They usually have to provide it in there, what's called initial disclosure, or you can do what's called a request for production of documents, which is a formal way of a written requesting the documents. So let's see what ALP's here, or ALP. Do debt buyers sue more now during the tax season? I can tell you, I don't see. I mean, they a lot of times they assume that there's more money because people are getting tax refunds. I think because it's really up to the attorneys. The debt buyers, they farm these cases out to the attorneys, and it's kind of like whenever they can get around to it, they file suit on it. Interestingly, in the Wall Street Journal about 6 months ago, there was an article about Encore Capital, who's the parent company to Midland Funding, and they were talking about their behavior during the pandemic. That in 2020, when COVID first hit, a lot of people, myself included, thought, well, there's probably just going to be a lot of bankruptcies. People aren't going to work. Maybe there'll be some programs or something, or some of these debt buyers will lay off the gas a bit. They said the exact opposite. They were full speed ahead, and largely due to the stimulus payments that the government was providing, they realized people had more cash than ever. And so they were filing more lawsuits to try to get access to some of that money. And people did pay down their credit cards for a while. I actually just read yesterday, I think it was on CNBC Online, that we have now reached a new all-time, it's the highest point, or the highest amount of credit card debt in America in the last 20 years. We just hit that. So, I mean, the good news is that they're not in default, but there's a lot of credit card debt out there. So it kind of just ebbs and flows, and there's really no rhyme or reason to it. You'd think bankruptcies would have been sky high in the last 2 years. It's actually 2021 was the lowest number of bankruptcies filed nationwide since the bankruptcy code was enacted back in the 70s. So, so kind of take that what it is. Any advice on dealing with Bank of America? Bank of America typically does not sell their debt. They keep it themselves. They sue on their own debt, and they want high settlements. Usually, I tell you, the original creditor lawsuits, whether it's Bank of America, Capital One, American Express, you're probably going to end up settling somewhere between 50 and 75% of the total balance, whether it's in monthly payments or a lump sum. It kind of is what it is. They kind of have you, in a tough spot because they can go in and they're going to have the documents, they're going to have witnesses. It's not going to be like a debt buyer type thing. So, all right. See what PB has. What can I do if a process server lied about attempts to serve? They filed a non-affidavit of non-service and listed they tried 3 times. Checked my camera on the days listed, never came. Well, I would hang on to the video. I guess the question would be the issue. So if they're filing an affidavit of non-service, they may be asking the court to enter what's called an order for alternative service, where they can just provide it to you in the mail. It's probably neither here nor there. That's one of those things where you might win a battle, but still have the whole war to fight. So my general advice is to accept service, is just to open the door, take it, deal with it head on, because you have good defenses usually. And when they start Mickey Mousing around with the service, that's when all of a sudden, they get permission to. I always use the example in the old days, they used to allow them to post it in the classified section of these like little random newspapers, and no one would ever see it. And so it ended up with the default judgment every single time. And once default's entered, it's hard to unwind that. So I always say process server goes by. In this case, the problem is it doesn't even sound like they're coming by, but maybe even just reach out to the plaintiff and say, I'll accept service. Just send it over and I'll fill out the documents. That's what I'd take a look at. So, all right, let's see here. See what Derek has to say. What should I do if a defendant What should a defendant usually do if the answer has been filed but the plaintiff's lawyer hasn't responded? So there is no response to the answer. So there's the complaint and the summons. They serve you with that. You have a period of time to file your written response called an answer. And usually there's no like reply or anything that's submitted to that. So the next step after that is usually initial disclosures. Most states, the federal government, they have this initial disclosure rule where you have to provide, essentially show your cards. You got to show your defenses. They have to show their claims. You have to show all the exhibits, that kind of thing. So it's not unusual that they haven't sent you anything, at least, fairly immediately after you filing the answer. What you have to watch for is sometimes I've seen this where you file an answer, and because over 95% of these end in a default judgment, they actually just, they don't do anything. I mean, the case will just sit there. And you ought to research the rules in your jurisdiction. Like in Arizona, in the justice courts, if a judgment's not entered within 10 months, the court's supposed to dismiss it. Sometimes if it just sits there dormant, we'll just file a motion to dismiss, try to get it thrown out that way. So, all righty, let's see here. I have a case that went to court. I lost the motion for private arbitration. The debt buyer dismissed without prejudice. It was put back on my credit report with them as owner. It's always frustrating to me when the courts deny the request for private arbitration. I have my own opinions about the courts as far as why they're doing that, but because it's a creditor's contract. You're not just making something up. This is something that they wrote, something that they should be enforcing. So I think that, and here's the thing, if it gets dismissed without prejudice, and even if it gets dismissed with prejudice, if it's dismissed with prejudice, all that means is they can't refile a new lawsuit. They can still try to voluntarily collect from you. And so it's important to know, this is kind of a side note to Joanne's question. If you agree to dismiss the case with prejudice, you also need to have a settlement agreement and a release, a separate document where they're saying, we're not going to, this debt's done. We're not going to try to continue to collect on it. Because if you don't, I've seen it where they dismiss the case with prejudice and then they start just sending collection letters trying to get you to voluntarily pay that. So, all right, Darlene, thank you for that. I appreciate that sincerely. Let's go down here to Matthew. Thank you. Appreciate your support of the channel. What do you think would happen if I moved overseas with 4 pending lawsuits and filed an address update with a court and plaintiff with a foreign country? Would they bother you anymore? I think what would happen if the lawsuits are pending, they would probably still move forward with the case. The court may end up entering some type of default if you don't show up to trial, or they may file a quick motion for summary judgment, knowing that you're not going to respond to it. The question there is, what are they going to do with the judgment? I always say, filing a lawsuit, if you get a judgment, now you got to collect on it. The court doesn't, surprisingly to a lot of people, the court doesn't like set up payment plans on your judgment. The courts only rule, they're like the umpire. They're there to say, are you liable or are you not liable? And if you're liable, here's a judgment, and they give it to them and say, good luck with that. If you live in a foreign country, they're not going to be able to pursue assets in a foreign country. They could pursue things like bank accounts. Like if you had an account like at Chase or something like that, they could serve it on a local Chase branch in the United States and still garnish money there. So, but it's likely that there's not a whole lot they could do once you leave the country on that. So, Derek, thank you. I appreciate that sincerely. So, let's go back to Darlene's question. This is a good one. Is there ever a good time for the defendant to file summary judgment against the debt collector? This is a good question, kind of a complicated question. If you're sued by a debt collector, they will eventually file a motion for summary judgment. Almost all these debt collection firms, they're ran by just a handful of attorneys. They file thousands of lawsuits. They can't go to trial. They can't do a trial on everything. And so they file a motion for summary judgment, which is just basically them saying, hey, judge, we don't need a trial. Just look at all these documents and tell us that we win. You have a chance to respond to that. And usually you can defeat that. But the question here is, well, what about you? Do we turn the tables on them and file our own summary judgment against them? I can tell you, I almost never do this. I'm trying to think if I've ever done it. The reason is, summary judgment is only granted. The standard is that it should only be granted if basically the parties agree on the underlying facts, and they just need to have the judge make a legal ruling. Basically, if everybody's just saying, yeah, we all agree this is what happened, just you look at this judge and tell us how the law applies to these facts. That's particularly in a debt buyer case, that is not what you're arguing. Your defenses are, look, Midland Funding is alleging that they own a debt that I had, but they're not providing me squat as far as documents. So there's a factual dispute because they're saying, hey, money's owed and it's been transferred to Midland or to portfolio or whoever. And you're saying, no, I don't agree with that. And so because of that, if you were to come in with a summary judgment motion, it's probably not going to, essentially you're trying to say that there's no factual disputes. And so I don't generally do it. I prefer the motion to dismiss for arbitration or just fighting it head on. I had an arbitration hearing this morning. Arizona has what's called compulsory arbitration in Superior Court, where they assign an attorney to act as the arbitrator. And I prefer to fight those things kind of head on, just like that. So, all right. This is a scenario I see quite a bit. Tamika's here says, I did a consolidation with my debt. However, the credit card company decided to sue me. What steps can I take to have it included in the consolidation? So here's what I see. With consolidation, I'm assuming you're meaning like there's some of these debt settlement companies out there. Freedom Financial is a big one. They do a lot of stuff nationwide. The problem that I see with that model of trying to deal with the debt is what they do is, so like a debt consolidation company, they come in and they say, okay, we're going to take all these accounts and we're going to try to negotiate a settlement. And then they start charging you a monthly fee that you pay for. And then what they do is they take that fee and they put it in like a savings account or like an escrow account until they build up a balance that's high enough that they can then reach out to your creditors and make some kind of settlement with it. The problem with that is your creditors aren't on board. Often they don't even know about it. So I can tell you, I do bankruptcy, so I can't tell you how often I meet with people who say, it's exactly what Tamika is saying here. I have been paying all this money to this company for the last 12 months thinking that we're getting this resolved. And then bam, I get hit with like 3 lawsuits right out of the gate. Often it doesn't work. Essentially what you're doing with those kind of companies is you're paying them to be a forced savings account, which is, there's some benefit to that. Cause if it's something where you struggle to put money aside, this kind of forces you to do it. It's kind of a pricey way to do it. But usually the credit cards are not on board. And that's why you get hit with these kind of lawsuits like that. So, all right, let's see what King Arthur has to say. Is it best to wait until the debt buyer violates regulations many times when they sue later and then use it against them? The debt buyers, they do have to follow the Fair Debt Collection Practices Act, the FDCPA. This is a federal law that basically says debt collectors, they're supposed to do certain things and they can't do other things. If they're violating the FDCPA, let's say that they're contacting your brother and saying, hey, did you know King Arthur owes all this debt and where the heck is he? We want to make him pay it. That's a violation of the FDCPA. Or if they're calling you every day at 6 a.m. and saying, letting it ring and waking you up, those are all violations. You can bring those violations as a counterclaim. So if you get sued by, junk debt buyer guy, they sue you, you can bring a counterclaim. So you file an answer and a claim against them for violations of the FDCPA. The only thing is, as far as waiting, like you were talking about, the FDCPA has a 1-year statute of limitations. It's very brief. 1 year from the time that you become aware of it. If you don't bring your counterclaim or file a suit against them, then it's barred forever. So that's something you got to, kind of think about right there. All right. Daryl says, I just got a final judgment against me. The attorney's office sent me a form to fill out called a financial information form. Do I have to fill out this information and send it back to them? I can tell you in Arizona, you don't have to voluntarily do it. But once they have a judgment, they can do post-judgment discovery. And so if it's something like that, where they're sending over interrogatories, requesting information, or sometimes they'll even hold what's called a judgment debtor's exam, where they'll bring you into court and require you to turn all that information over. They often can. So that's another, reason 1,000 that you want to avoid having a judgment, because then they become entitled to a lot of information that they wouldn't otherwise. So, all right, let's see what Greg has to say. This crazy housing market has inflated my home equity numbers. Can a debt collector force a bankruptcy or anything that can attach an equity loan like a reverse mortgage? So the debt collector can't force you into bankruptcy. I mean, there are these things called involuntary bankruptcies, like 5 of them happen a year in the country, and it's not going to happen against you. But what we are seeing is in a lot of states, if they get a judgment against you, they can then record it with the county recorder, and then it can act as a lien against your home. So that's, again, reason 1001. You want to try to avoid the judgments and get into arbitration or something like that, or get it settled or whatever you're going to do. Because if that's one thing that they are seeing is a lot of particularly the larger debt buyers, they kind of play the long game with this. They'll get a judgment and they may realize I can't garnish your wages, but I'll record this because I see you have a home with a lot of equity in it. And then when you go to sell it or refinance it, I might be able to collect on the back end. So that's something that generally they're not going to push you into bankruptcy or anything like that, but you got to be careful with it. So, all right. This is part 2. In an Arizona bankruptcy, can a home be forced into an auction to get at that equity? Mortgage of $100,000 with real estate resale value for $450. Excuse me. So Arizona has a homestead exemption of $250,000 of equity is protected. And that's new. It was $150,000, but January 1st of 2022, they bumped up to $250,000 of equity is protected. So in a scenario like this, where you have a mortgage of $100,000, and if the value is $450,000, that means you have $350,000 of equity. If you file Chapter 7 bankruptcy, yes, they can force you to. They won't force you. They'll just go sell your house. They'll sell your house. They'll pay off your mortgage. They'll write you a check for $250,000 because that's your homestead exemption, and the balance goes to your creditors. In a situation like that, if you still need to file bankruptcy, I recommend a Chapter 13, because in Chapter 13, they're not going to force the sale of your home, but you're going to have to pay out quite a bit of money to your creditors in order to get through the case. So, all right, let's see what else we have here. This is a good question from Candace. Can you settle for less after losing the summary judgment? Yes, you can always settle. And it goes back to what I said earlier. Just because they have a judgment, that doesn't mean they have money. And they, particularly if they don't have a lot of information on you, or, I talked to a person today, their income is Social Security, they were renting their home. And so there wasn't a lot of hammers they could do. You can't garnish Social Security. You can't, if they don't own a home, they can't go after that. So you can come in and you can offer something. But even if your situation is not like that, if there's a judgment for 10 grand out there, just go in and offer 4 grand, even if summary judgment's been entered. At the end of the day, they want money. And if you're offering money, there's always a deal that can be reached. So TP, thank you for the super sticker here. All right. Here's another question about judgments and home liens. If you own multiple homes, can they put a lien on all of your homes or just one? So this is, again, real estate property is very state specific. So I can only give you the Arizona answer. So if you're in Arizona, the answer is they can take the judgment and record it. And whatever county recorder they record it in, it'll act as a lien against all real estate in that county. So I'm here in the Phoenix metro area, which is Maricopa County. So if they get a judgment recorded in Maricopa County, it acts as a lien against all of your property, no matter how many properties you have, whether it's a home, it's vacant land, whatever it is, it'll act as a lien against that. But if you have a home in Pima County or Navajo County, and if they don't record it in those counties, it doesn't act as a lien against that. So let's go back to Darlene. The judge denied Midland Credit Management's motion to continue so they could file a summary judgment. Yay. Going back, this is a question from last week where I see this. I'm seeing this. I've seen it in my own case load, where the there's a deadline. Usually you can't file a motion for summary judgment within 90 days prior to trial because there's just not enough there's not enough time for the court to process it. And so they were filing a motion to continue a trial that's been set forever in order so they could then file their motion for summary judgment. And so I'm glad to see that they did that. So you're heading to trial. Follow-up question then says, do you ever mention that these collection lawsuits are misleading or fraudulent? Well, I don't know if they're fraudulent, but they definitely don't have the evidence that they need in most cases to support it. So, for example, in the arbitration hearing I did this morning, I cross-examined this witness from a junk debt buyer, Absolute Resolutions. And so she was testifying about, the documents from another entity, from another bank. And on cross-examination, the first thing I asked her is, one, when did you first look at these documents? 8 days prior. Before that, she'd never seen them. And I said, look, both the attorneys and the arbitrator have spent more time with these documents than their witness has. And I said that in the hearing. Two, she admitted she'd never been trained by any of the original creditors. She didn't know how they kept their books. I asked her, did you ever reach out to the original creditor to verify the information? No, she didn't. So you can really paint a picture that they're saying all this stuff, but it's just words, that there's nothing there's no substance behind it. They're just parroting what's in the rules to try to get them through, even though they don't have any real idea about the underlying substance. So, all right, we'll do one more for Darlene here. If you are collection proof, or we call it judgment proof, with Social Security income only, should this be brought up during the trial or it's irrelevant? It's not relevant. That's a good question. It's not relevant at the trial stage. Again, the judge is only there to determine whether you're liable or not liable. That's their only determination. They're not even thinking if it's collectible. If they get a judgment and you're trying to settle it, and if your income is Social Security, I always say disclose that, because they can't touch it. They can't touch it they can't garnish it. They can't touch it if it's just sitting in a savings account, and it makes it gives you a little more leverage in trying to get it done. So, all right, Cigar Dude, let's talk about this. You're in Kansas. Blinton Gaines is representing Capital One on my credit cards for $3,900. Can I get a settlement due to income loss during this pandemic? Yeah, they will. I have a number of matters with Blinton Gaines. They do collections here in Arizona as well. And those, like I always say, settlement is, they don't want to go to trial. They don't want to even file lawsuits if they don't have to. That's why they send out collection letters. Lawsuits are expensive. They cost the creditor money to do that. And what they want is to get money in their pocket and move on from this. And so original creditors like Capital One, they typically don't sell their debt. Sometimes they do, but mostly they don't. They're going to require more in a settlement. Like in my experience on a $3,900 card, you're going to probably pay something between $2,000, $2,500 probably to get that settled. If it was a junk debt buyer, like a Midland Funding, they'd probably take $800 to $1,200 to get something like that done. So just kind of depends on what you have there. So, all right, let's see what Task. Thank you for supporting the channel. I had a lease for a business equipment and I defaulted. My attorney is using the defense of non-mitigation. Is that a good defense? Yes. Anytime there's a lease agreement. So here's the issue with the lease. There's just a big kick in the teeth when it comes to leases, and particularly business leases, is if you default on it. So let's say I have an apartment lease for 5 years, or let's do a business, because business leases are really long. So you enter into a space lease for your store for 5 years, and you default after 1 year. Well, under the law, they can come after you for all of the payments for the remaining 4 years. So you just get sued for hundreds of thousands of dollars. And I'm sure it's the same here with this business equipment. They're going to say, hey, you still had 12 months left on the lease or whatever it was, so you need to pay for each and every one of those payments. However, the landlord or the creditor, the lessor, needs to mitigate their damages. They have got to show that they tried to relet the apartment out, or that they tried to take the equipment and lease it out to somebody else. And if they haven't done that, that can reduce the amount that's owed. We often see in building spaces or leases that they will often, if we see it here with Arizona State University, it's just down the road. I see this with landlord-tenant issues there, where a student there leaves early, they're able to refill that thing within like 2 weeks, and then they sue for the full balance of the lease. They can't do that. They can't double dip if they If they did what they're supposed to do and mitigate their damages by getting someone else there, they can't do that. They can only get one payment for it. And if they haven't taken the appropriate steps to be able to mitigate their damages, you can reduce the overall damages and what's paid there. So, all righty, let's do a couple more. Let's see. Noob says, would a $3,000 debt be worth it for a plaintiff to go through with private arbitration, or do they usually dismiss? I have never seen them go to private arbitration, ever. So I don't think they will. The filing fee with AAA, with the American Arbitration Association, and with JAMS, those are the two companies they use. The filing fees for them are $2,000 plus. For you, it's only a couple $100, but they're not going to do it. It's out of their wheelhouse. It messes up their whole system, and it's going to cost more, particularly on a $3,000 debt, than it would be worth. So, let's see what Davey Boy says. What if you have no income and have not in 10 years? Had an injury. I have 4 cards at about $6,000 to $9,000 each that I have not paid in a few months. I'm just getting ready for what's to come, and you own no home. Well, part of it, I can tell you this, because sometimes people say, will I get sued? You see it on your credit report, and so you're all stressed out. Are they actually going to do it? They evaluate it, and particularly the larger debt buyers, they have what am I thinking here? I'm thinking of AI kind of stuff, or like Moneyball. What's that in Moneyball, where they have they look at the numbers. They know, particularly credit profiles. They know if the information that they have on you of whether it's worth their time to pursue it. So if they're seeing on your credit report there hasn't been a current employer in a number of years, or if they see that there's some other indication there that it's going to be a very difficult debt to collect, they might send some letters, which you may not get sued, or they could sue. Particularly if they sell it off to a lower level debt buyer, they may try to sue on it. I've seen lawsuits on some of the people who just are really struggling and don't have any assets to go after it all, but they still try to get that judgment. So they could still do it. It's kind of hit and miss. And I know that answer doesn't help at all. So I'm sorry about that, but it varies from debt buyer to debt buyer, case to case, law firm to law firm, whether they're going to actually do it. So, all right. I think we're going to wrap that up. We're at about a half hour there, but hey, I appreciate everybody checking in, getting every week. We seem to get more people on this, and I'm glad we can help out. If you want to learn more about my law practice, I'll put a link down in the comments. I work at the law firm Jackson White in Arizona. There's a whole page about our bio. I'll also put a link for the online tutorials and the templates that I have. They're really designed to help people who are representing themselves in these types of cases. But with that being said, I appreciate you